My Lord, a couple of days more to Ghana's biggest elections by far. How ready is the Supreme Court for election-related disputes?
The judiciary is to adjudicate disputes that arise in the normal course of life and in all circumstances. And so the Constitution vests judicial power in the judiciary. And it's a sacred trust that judges exercise on behalf of the Ghanaian people. And it's a trust that the judiciary takes very seriously and have always been ready to deal with all manner of disputes, including election-related disputes. Because of the importance, first of all, of public elections and its impact on society. It's a process by which we exercise our franchise and invest in a selected group of people, in a national, if you want, election, invest in one man. All executive powers of the Republic, and invest in selected people at constituency levels, all the powers of the people, and that's how we elect our members of parliament and our president. And once this sacred process is over, our destinies, our future, the well-being of our society, which direction they take us and do not take us, is for the term of that government invested in that selected group of people. It's a hugely important exercise, and that is why it has attracted particular and special attention from the judicial service. It has always been the case, and that seriousness and that priority that the judiciary attaches to election-related disputes and their adjudication is a front burner issue for His Lordship the Chief Justice and the entire judiciary at the moment.
Any electoral disputes arising from this year's elections will be adjudicated within 42 days. And that's record time. In the last petition, it took us some 8-9 months. You appear to be snowballing the wheels of justice.
That's not the case. Coming from our experiences in the last election petition, that Parliament by law has set timelines for the resolution of future presidential election disputes. And so that timeline of 42 days within which any presidential election dispute ought to be resolved was not set by the judiciary. It is set by law. It's an amendment to the existing legislation that makes that provision. The timelines provided in the legislative instrument are consistent with the timelines by law, including the Constitution. It does not. If you go to the relevant instrument in this book, and it is for that reason that His Lordship the Chief Justice mandated an eminent committee to review the 3rd edition of the Manual on Election Adjudication in Ghana. And the purpose of this review is to update it and reflect all the amendments to the law and the new laws that have been passed. And if you or anyone who is interested in this subject procures a copy of this book, the answers to the questions you are posing are set out in this manual. It's simple, it's easy to read, it's clear to understand. And to ensure that it's not an opinion, what we have sought to do in this manual, and I was the most junior member of the committee, what we sought to do in this is to compile even all the legislation in full text and with their schedules.
My Lord, during trials, there are exposés. A lawyer would have to cross-examine a petitioner for a number of days. Sometimes it takes months. If a lawyer is not done with cross-examination, are you going to truncate the process?
In litigation generally, litigation civil proceedings have a timetable. Time is not at large. Even when your course of action accrues, generally in litigation, there are timelines in law when you must act, or the law will tell you forever remain silent. It's gone. If a judgment is rendered against you, there are timelines within which you must appeal, you must protest, and if you don't, at the lapse of that timeline, the law will tell you forever remain silent. If you can live with this for this period, you live with it forever. So time is of the essence in every type of litigation. So there's nothing new about it. That said, all of the timelines are introduced having regard to what we call the ends of justice. We must always make sure that at the end of the day, justice is done. And it is in the ends of justice that you must know that litigation must come to an end. So if somebody had a dispute with your father, which was resolved some way or the other, and the person is not happy, went to sleep, you grow up at your age, then somebody comes and resurrects some dead case against your father, against you. Is that fair? Is that just? Is that so? The timelines are dictated by the ends of justice, and it is inherent to litigation. Now, but within those timelines, judges or adjudicators have flexibility. The judge controls the proceedings and does so in discretion. But that discretion, the judge does not exercise willfully or capriciously, arbitrarily, out of ill will or favor. The law regulates all of that. You know, I always tell people, there is no mischief in the human imagination that the law has not anticipated and provided for. Provided those who are using the law, such as lawyers and judges, know how to use the law. Therefore, within that time frame, if you went to court on any process, and I've seen you in court before, my first meeting with you many years ago was in court, you will see that you rise to your feet and a judge on top of his brief will say, Mr. Pappoe, can you tell us why we should not grant the application by your friend? You resume your seat. He calls your friend, Prince, and say, Prince, move your application, let me hear you. You start, the judge will stop you, he will ask you a question, you will clarify the question. At the level of the Supreme Court, where trials are generally by record, before you appear, you would have filed all your processes.
A member of the NDC legal team believes that the 21 days period within which a petitioner is allowed to file a petition is what should remain, because what we currently have is that you have 7 days within which to file a petition, and he thinks that that flies in the face of law and believes that because it's an entrenched provision in the Constitution, we should have a referendum.
So first of all, I have told you that because of my status and my role, I don't proffer opinions outside a judicial chair. This is not a judicial chair. I'm here as a simple member of the committee that the election manual review committee assigned to basically tell the world that there is this manual out there and that is a compendium of all the rules. I think that what informed the legislation And it's not the judges who passed the law. It's not the Supreme Court that passed the law. The law was passed by Parliament. So you should go address these questions if you have issues to the parliamentarians. Indeed. Now, we have two instances, I'll tell you. Okay. So you have an election petition that took 9 months and hijacked the imagination, the emotions, the sentiments of the Ghanaian people for 9 months. Is that progressive? Is that constructive? Is that a proper way to administer justice? Was that just? Was that fair? Sovereignty belongs to the Ghanaian people. The powers of justice that judges exercise, we do as trustees and agents for the people. Was that fair to the people? Was that a judicious exercise of the people's power? So coming from that experience, there's a classic. Ayawaso Amo was elected. I think this was in 2003. By the time the dispute was resolved, the life of that parliament had lapsed. All I can say is that the answer to Mr. Amaleba and those who share his sentiments may be found in this book. So they should find this book. I'm not the one to provide that answer. I will have an opportunity to provide an answer if it ever became a dispute before the Supreme Court, and I have the privilege of being empaneled by His Lordship, the Chief Justice, to speak to those issues.
In this new law, any suit challenging a presidential election will only be allowed from contestants and only against the winner and the Electoral Commission. Can you bring clarity to this matter?
You know, causes of action are personal to certain people or entities. I guess the rationale is very simple. Who runs the election to be elected as president? Adotei Pappoe of TV3 runs the election as the candidate of TV3 to be elected president of the Broadcasters Association. Adotei Pappoe, for some reason, loses or finds objection to some process or some event in the election. Whose course of action is it? Who is affected? Who becomes president? Is it Adotei Pappoe? And it is the party who is affected that must go to court.
Finally, my lord, and this question you can choose to answer it or ignore it. Now, many have said that there were indeed widespread infractions in the 2012 elections, but judges used the mischief rule to give judgment.
There's the golden rule and there's the literal rule. Why do you think judges usually opt for the mischief rule?
All I can say is that the 2012 election dispute was duly adjudicated upon, adequately considered. In fact, it's one of the single most exhaustively considered pieces of litigation in our judicial history. You know, every one of the 11 justices proffered their own opinion and wrote their own judgment. So even when they agreed with each other, each one wrote their own reasoning why they agreed. And so if you saw that single case, the reports are in volumes. Why was that? It's because of the gravity of the matter and the importance that the court as a court and the judges individually appeared to attach to that case. There's no case in which the issues were so exhaustively and extensively considered as in that dispute. And so anybody who has reservations, questions, issues about those matters, they are not for challenge. The court spoke, it's final, that is the law, and it's rested in record in the volumes of the books. So if you have questions, you just go back and re-educate yourself. People may have dissatisfactions, which is not unusual with the law. So you go and write in University of Ghana Law Review or some law journal where, you know, people evaluate and review and criticize judgments and proffer other views. And even as judges, we read them because knowledge has no end. And in the future, we take shortcomings, pluses, minors. That's what the academics in the faculties of law around the world do. They review, and there's a principle that when we finish our work, we're given to commentary. And so people are allowed to think through it, review it, analyze it, and you will see why are we having this conversation. Because since the last election and now, even Parliament has changed some of the laws. And that is why we have a revised 4th edition of the Manual on Dispute Resolution, in order that we can update it and bring all the current knowledge and new learning and new direction and perspective that we're charting for ourselves as a country into one simple book that stakeholders, lawyers, judges, students, everyone can access.
My Lord, we're most grateful for this time. Thank you very much.
I'm grateful. Thanks for having me.